Counsel for the petitioner submitted that a valid detention order should reflect that the authority was aware that the detainee was already in prison under judicial custody, and there was reliable material before him on the basis of which he had reason to believe that there was every possibility of the detainee being released on bail, and in case of such release the detainee would indulge in prejudicial activities, and in order to prevent him from indulging in any activities affecting the public order or the tranquility of the community, it was imperative to pass an order for his preventive detention, and unless the aforesaid satisfaction is recorded, the application of mind by the detaining authority cannot be proved, and testing the impugned order on the aforesaid principle, the impugned order appears to suffer from vice of complete non-application of mind, Learned counsel for the petitioner next submitted that since on the date of the passing of the detention order, the petitioner was already in jail, and mere possibility of his release on bail was not enough for preventive detention unless there was material before the respondent number 2 justifying the apprehension that detainee would indulge in prejudicial activities in case of his release on bail, He next submitted that although the detaining authority has in the grounds of detention recorded his satisfaction that the petitioner who was in jail on account of his being accused in case crime number 333 of 2015, under sections 147, 148, 149, 452, 307 IPC, had moved a bail application before the sessions judge, and there was strong possibility of his being released on bail, and in the eventuality of his being released on bail, he would again indulge in similar activities prejudicial to the public order. But in the instant case, there was no material made on apparent on record that the detainee, if released on bail, was likely to indulge in activities prejudicial to the maintenance of public order, and hence the impugned detention order cannot sustain and is liable to be set aside, In support of his aforesaid submissions, learned counsel for the petitioner has placed reliance on Shashi Agrawal versus State of UP and others reported in 1988 1 SCC 436 para. Per contra, learned AGA submitted that the impugned detention order does not suffer from any illegality or infirmity requiring any interference by this court, He further submitted that there was sufficient material before the respondent number 2 justifying his belief that in case the detainee was released on bail, he would again indulge in activities disturbing the public order, para. We have very carefully scanned the impugned order and the grounds of detention and also the counter affidavits filed on behalf of the respondents number 1 to 4 in this writ petition, and we are constrained to observe that no material justifying the apprehension that detainee would indulge in prejudicial activities in case of his being released on bail was placed before the respondent number 2,